Hi guys, welcome to my channel, The Legal Affair with myself, Attorney Bay. As always, we talk all things law, and our conversation today is on employment. Please, of course, do remember to subscribe to our channel on YouTube, The Legal Affair. You can also follow us on social media, The Legal Affair. You can also follow me on TikTok and Twitter at attorney_bay. So in the South African space, the employment space rather in South Africa is regulated by various laws or pieces of legislation. Some of these laws include the Basic Conditions of Employment Act. We've got the Employment Equity Act, we've got the Occupational Health and Safety Act, we've got the Labor Relations Act. Now, these acts or laws in South Africa speak, of course, to the obligations that an employer has as well as the obligations that an employee has. So, in the employment space, of course, the employment conversation is quite broad, and really today we talk on a number of themes or topics in the employment. Number one being social media and employment. So, employers are permitted legally, of course, to dismiss an employee on the basis of what the employee posts on social media. So, I think it is quite important if you're an employee that you are aware or cognizant that your employer actually has a right to dismiss you on the basis of the content that you put up on social media. Important also, if you are an employee and you spend an excessive amount of time in the workplace on social media platforms, that is another ground within which your employer can actually dismiss you. So it's important that you're mindful when you are at work, if you're spending an excessive amount of time on social media, that is a ground for your employer to dismiss you. Important also is for those who are in the job market. Many companies usually do like screening or vetting before they actually hire you. Sometimes actually ask for your social media profile, and it is of course legal for a company to choose not to hire you on the basis of the content that you put up on social media. So when it comes to the employment space, also the relationship between the employer and employee is regulated by your employment contract. Ordinarily your employment contract would set out your working hours, your remuneration, the number of leave days you have, the obligations that you have depending on the nature of work that you have, the obligations that your employer has, and so forth. What is important, I think, when it comes to employment agreements, number one is that if you are an employee, you have a proper understanding of what your obligations are as an employee. Important also is that you have a proper or thorough understanding of what the obligations of your employer are. Three, I think it's quite important that if there is a dispute or a disagreement that you have with your employer, it's quite important that you are aware of what procedures or formalities or steps you are required to follow, in order to try and resolve this particular dispute. I make mention of this because we've seen in South Africa employees being dismissed because they have, vented about their employer on social media, whereas that particular employer actually rather had a social media policy. So if your employer has a social media policy and you violate or you are non-compliant with that social media policy, it is a possibility that you are dismissed. So if your employer, for instance, has a method or steps that you are required to follow in order for you to resolve a dispute or disagreement, I think it is quite important as an employee that you are aware or you establish that you understand what those steps or processes are. Now, when it comes to the employment space, like I mentioned, we have various pieces of law or legislation that regulates it. Also important when it comes to the employment agreement, I think some of the things that I could term as do's and don'ts when it comes to employment agreement. Number one, definitely don't use your work equipment or tools for personal usage. An example would be if you are given a cell phone, or you are given a vehicle, avoid using work related items for personal usage. So driving your a vehicle, a work vehicle for personal usage, using your work cell phone for personal usage. Important also is that you could be in contravention, in other words, in violation of your employment agreement. Another don't I would definitely say is that if you come to an agreement with your employer, always make sure that you avoid verbal agreements with your employer. So if you come to an agreement about a raise or an increase, about your bonus, any sort of agreement that you come with or come in conclusion with your employer, don't have verbal agreements. Always ensure that those verbal those agreements that you have are agreements in writing to avoid disputes in future. Important also is that if you choose to use social media in the workspace, don't use social media excessively. As I've mentioned, it is a possible ground for you to actually be dismissed for excessive usage of social media in the workplace. I think it's also important, like I've mentioned, employers actually do background screening. Employers also do verification of qualifications. Your employer is entitled, of course, to verify your qualifications before they hire you and during your scope of employment. In other words, even after they've hired you, they can also do. They, being your employer, can actually do a background screening. Once again, they can also do a verification of your qualification. So it is quite important also that you are mindful that in the South African space or context, it is an offense to lie on your CV. Your employer also has grounds, of course, to dismiss you on the basis of lying on your CV. So not only can you actually be dismissed from employment, but you can also be sent to jail. Now, when it comes to dismissal in the workspace, there are various reasons within which an employer can dismiss an employee. Number one being conduct. Conduct is quite extensive. I don't necessarily think I can give you a list of factors of what would constitute a reason for an employee being dismissed for conduct. But some examples would be you're dismissed because you are late on an ongoing basis. You are dismissed for theft in the work environment. You are dismissed following various, verbal, written, and then final written warning, and then dismissal. So it is quite important if you are an employee. I think if there is what is deemed to be prohibited conduct, in other words, things that you are not permitted to do, you are aware of what constitutes prohibited conduct. An example of prohibited conduct would be theft or stealing in the workplace. Another ground for which an employee could be dismissed is operational requirements. Now, operational requirements rather speak to the organization. The operational requirements are usually when an employee, and rather an institution or an entity, is actually not generating enough money. So the employees would then have to be dismissed. Of course, with operational requirements, the employer has an obligation to ensure or to prove that they don't have any other alternative but to dismiss. So usually with operational requirements, it's when a company is not doing well financially and the employer makes a decision to cut down on its staff. Important, of course, is that if a employer chooses to dismiss employees on the basis of operational requirements, the employer has an obligation to actually prove or to show that they have no other alternatives but to dismiss those particular employees. And lastly, one of the grounds within which an employer can dismiss an employee is incapacity. So when it comes to incapacity, incapacity is broken up into two. Now, incapacity could be meaning poor work performance. In other words, you are not performing well at work, and incapacity could also mean ill health. In other words, you are not doing well, or a disability. Now, with ill health and disability, it would depend on context. You can't just dismiss someone because they are ill or because they have a disability. You'd need to have an understanding of the context within which you choose to dismiss that particular employee. Very interesting, I think, in the South African space is we have some important legal developments in the employment space. We have the Employment Services Amendment Bill. Now, the Employment Services Amendment Bill, of course, brings quite a number of proposed changes in South Africa. One of these proposed changes, we see the introduction of what is a worker. So in the South African space, we differentiate between people who are, or persons who are regarded as employees and persons who are regarded as independent contractors. So, and there could be people who are neither an employee or neither an independent contractor. And what we see with the proposal of a worker is essentially saying that any person who receives payment in cash or otherwise may be classified as a worker. What I think we can learn from the introduction of this definition of a worker is that it is quite broad, number one, and number two, even if you don't have the intention for someone to be a worker, depending on context, of course, because the definition of worker isn't very broad, that person could actually be regarded or classified as as a worker. Some other new proposals that are brought into existence by the Employment Services Amendment Bill is the introduction of a limitation of the number of foreigners that we see. So there could be a quota that may be imposed by the Minister of Labour and Employment on how many foreigners a company is permitted to run or rather to hire. There could also be a quota, like I mentioned, that is imposed by the minister. And if a company chooses not to comply with the quota, that company would need permission or consent. We also see the regulation, which I think is quite important, of people who work on digital or online platforms. Now, something that I think is quite an important conversation in the employment space is the payment of UIF. COVID really showed us that there are quite a number of employers who actually were non-compliant with UIF. In other words, they were not paying UIF on a month-to-month basis, which is rather unfortunate because many people were dismissed because companies were not doing well financially. And when they tried to claim UIF, they realized that their company actually wasn't paying UIF. So number one, when it comes to UIF, employers have an obligation to pay UIF on a month-to-month basis on their employees. Number two, employers aren't allowed to skip UIF. So you can't pay for 1 month and then skip another month and pay another month and skip another month. It's important that you keep up with UIF payments on a month-to-month. You can actually verify or check if your employer pays UIF on your behalf by going and contacting the UIF. Important also, it doesn't mean that if your UIF contribution reflects on your salary, or on your payslip or your salary advice, that your employer is paying UIF. So don't make the assumption that just because there is a UIF contribution on your salary slip or salary advice, that it is being paid. Rather, if you are uncertain if it's being paid, you can actually contact the UIF to verify, if your employer is paying UIF on your behalf. Important also, who can actually claim UIF? Quite extensive. Number one, persons who are dismissed from the employment space. Number two, persons who are ill, in other words, you are incapacitated and unable to work, and you are forced not to, you are unable to go to work as you usually do. Number three, people who fall pregnant, in other words, you take maternity leave, and you are also permitted to claim from the UIF if you have adopted a child as well. So I think when it comes to UIF, like I had mentioned, COVID really taught us in the employment space not to assume that employers are paying UIF. It is quite important, in my view, that you verify with the UIF if your company is paying UIF on your behalf. And as mentioned, of course, the obligation is on the employer to ensure they pay UIF. Employers are actually not permitted to skip UIF. You're required to pay UIF contributions on a month-to-month basis. What's also important when it comes to payment of the UIF is that if you resign or abscond, in other words, you disappear from work, you are unfortunately unable to claim from the UIF. Lastly, like I had mentioned, when it comes to employment agreement, your employment contract, it is regulated or regulates the relationship between yourself as the employer and the employee. I think it's quite important when it comes to resolving disputes with your employer. As an employee, you understand what processes your employer has. Of course, we have the CCMA, which is a forum that you as an employee can resort or go to. A benefit that the CCMA has is that you don't necessarily need attorneys to represent you at the CCMA. Rather, as an employee, you can represent yourself, but you can also have attorneys represent you. But I think it is quite important that you have a look at your contractual agreement with your employer just to see what obligations you have when it comes to trying to resolve disputes with your employer. Sometimes, for instance, you're required, to report whatever disagreement or disgruntlement you have, in writing, and of course to try and resolve it internally before it is taken externally. So from our conversation today, I hope that you have learned or have understood the importance of going through your employment contract, understanding your rights as an employee, understanding your obligations. Important, I think, that you are aware of the influence social media has on you as an employee, specifically because you can dismiss because of the content you put up on social media. I think it's also important that I actually mention that in the South African space or context, you can also be dismissed for office gossip. It's quite important, of course, to have context, depending on, of course, also on the nature of the office gossip. So it is important, in my view, that you are mindful that it's not just social media or the content you post on social media. You can be dismissed for office gossip. It does, of course, depend on context. You're not just going to be dismissed because you are gossiping, and it depends on the nature of the gossip. In some instances, people are harassed through gossip. So I think it's important that you are mindful of your conduct as an employee in the employment space. Like I had mentioned, very important, there are things that you should try and avoid when it comes to your employment contract with your employer. Some of these examples include having verbal agreements with your employer. Rather avoid the verbal agreement. Always try to have it in writing. When it comes to the usage of company tools or equipment for personal usage, you need to be mindful that if, for instance, you use a company vehicle, a company cell phone for personal usage, when it's not intended to do so, that is also a ground within which your employer can dismiss you. As mentioned, also there are three grounds within which in the employment space you can be dismissed. The first ground being conduct. Like I mentioned, conduct is quite broad. There, an example being, you store something in the workspace, you are non-compliant with your employment contract, and so forth. The second ground is operational requirements. This usually speaks to the company not doing well financially and being forced to cut down the employees. And number three is capacity. Bearing in mind that when I spoke about incapacity is broken up into two. It can be ill health, incapacity, in other words, you're not doing well, and in the alternative, it can be poor work performance. Very important also, like I mentioned, in the employment space, it is a criminal offense for you to lie on your CV. Not only can you be dismissed, but you can also be sent to jail. For those who are in the job market or the job space, it's quite important that you are mindful that employers can do pre-screening before they actually choose to hire you. They can vet, check your social media profiles, check your qualifications, and they can choose not to hire you on the basis of the content that you that you put up on social media. And lastly, the UIF contributions. I think it's quite important, specifically in the with the wake of COVID that we've had. It has made many people realize that their employers actually might not be making their UIF contribution. Like I'd mentioned, it is a legal obligation that your employer has to pay UIF on a month-to-month basis, and they are not permitted, being your employer, is not permitted to skip UIF. And I think it's just important as an employee, you verify whether or not your employer pays UIF. Lastly, of course, in the South African space or context, we differentiate between those who are employees and who are freelancers or independent contractors. I think it's quite important that you understand the differentiation between the two, because if you're an employee, there are rights that you have, and some of those rights include having annual leave, being able to claim UIF, and various other contractual rights that you may have in accordance with your agreement, versus a freelancer or an independent contractor. We hope you enjoyed our conversation today, and please, of course, remember to subscribe to our channel on YouTube, That Legal Affair.